Webinar on personal support services. It's our fourth one in the series, and you're all very welcome. I'm so looking forward to this webinar. I think that it's a very hot topic. You know that I have to go through the first few slides the same every webinar we do because we have new people coming in to each of the webinars. Bear with me as I do that before we get into today's agenda. Let me put this on large screen so that I can see the slides. For those of you who do not know us, we are Communication Disabilities Access Canada, or CDAC. We are a non-profit organization Canada-wide based here in Ontario, and we promote human rights, accessibility and inclusion for people with speech and language disabilities, and we use SDL to shorten it in the slides. And that includes people who use augmentative and alternative communication, or AAC. We work on time-limited projects, and we are, depending on the project, we have different team members come together, usually speech-language pathologists, AAC clinicians, legal professionals, accessibility consultants, and we always include people who have speech and language disabilities in our projects. For those of you who are not familiar with us, I suggest you go to our website, and under the tab Our Projects, you'll see a number of the different themes, areas that we have focused on over the years since 2001. A little bit of new information for everybody. I'm very pleased to say that today CDAC was honoured in receiving the David Onley Leadership in Accessibility Award. We were one of 8 organizations in Ontario recognized for the work that we're doing in promoting accessibility for people with speech and language disabilities. So that's really nice, and we'll be putting some information about that on our Facebook. But I think for those of you who know our work, this is big for all of us. It's big for the fact that we are being recognized, that the issue of communication access for people with speech and language disabilities, not primarily caused by hearing loss, is now on the radar. And I think that we can all be very proud of the efforts that we have made. And I'm spreading that way beyond CDAC in getting that recognition. So we should all be proud of that. This webinar series is funded by the Law Foundation of Ontario through the Connecting Communities project, which is run by the CLEO, by Community Legal Education Ontario. So we're grateful to Catherine Hunter from the LFO and to Vivian Green from CLEO for supporting us on this. We are solely responsible for the content of these webinars. We have participants from across Canada. We have participants from very, very different perspectives on this webinar series, mainly speech language pathologists. We also have people who have speech and language disabilities. We have people, family members. We have lawyers. We have students. So disability advocates, people coming from different perspectives. So we won't keep everybody happy all of the time. There will be stuff that you know, there'll be hopefully stuff that you don't know. But what these webinars are about is to really start this conversation with the various stakeholders that are interested. And I think we've got those stakeholders at this webinar. We've got a good cross-section of people interested in it. Our presenters this evening, Brendan Poran, our lawyer, or he's not our lawyer, we'd like to claim him, but our lawyer working with us. Brendan works with Poran Law here in Toronto, specializing in legal services for people with disabilities and family members. Megan Hines is an occupational therapist who's worked with us many times on a lot of our projects. And Megan's background is as an occupational therapist, and she works at Sick Kids, but she's also worked at the Gage Transition to Independent Living. And then there's me, Barbara Collier, speech language pathologist, and I'm executive director of CDAC and project manager on all of our projects. I just very quickly, this is primarily to give you legal information about the issues, but we always want to balance that with information around communication. There's one thing to know your rights and what the law says. There's another thing that about being able to communicate and negotiate it if you have a significant speech and language disability. So we try to balance it and give you a bit of both in these webinars. The webinars are all being recorded, and we now have the first 3 webinars up on our website. You can go to the site and click and view those. You can share them with other people, and we are asking that you do that before June the 30th. So this evening's webinar is on personal support services, and on June the 14th, we will be talking about abuse and crimes within the caregiving context. Note that that's a Tuesday, and note too that Pamela Cross, who's a lawyer who's worked with us in the past, will be joining us for that webinar. How we have done, we're doing this webinar in the same way as we've done the others. We have grounded them in reality. We have interviewed people with speech and language disabilities and service providers. We've collected stories, we've collected the questions, and that has informed the content of the webinars. We will focus on what is happening in Ontario because that's our funding base for this. We hope that you will find some relevance if you are joining us from other provinces or areas. We will be sending you the handouts tomorrow. Note that we will not be sending you the slides. We will send you supplemental information. We're hoping that people will actually come to the webinars to see the slides or take the recorded version. Please, we welcome questions, and I'm sure there will be lots of questions at this webinar. Feel free to type them in as you think about them. Or at the end of the webinar, and we will go through as many as we can with the time that's left. What we're going to do today, Personal Support Services Ontario. Megan is going to give us an overview, a starting point. I find the system a bit confusing, to be quite honest with you, and I'm delighted that she's going to explain it to me and to you. So she's going to give you an overview of developmental services, attendance services, and the home care service models in Ontario. Brennan's going to tell us about the relevant laws to these services, and we are focusing on attendance services and home care services. We will be then looking at the Bill of Rights, as well as legal options if your rights are ignored. I think perhaps the most interesting part of it is going to be at the end when we are going to talk about or present some of the questions and scenarios that we elicited in our research. So at this point, I'm going to hand you over to Megan, who's going to give us a review of personal support services. Over to you, Megan.
Perfect, thank you. So I'm excited to do this webinar. It's kind of my bread and butter of what I do at work. So I really feel that quality of life for people with disabilities is really dependent on the quality and availability of these type of services. So what we're going to be talking about when we talk about personal support services is any kind of situation where a person is in your home, a paid person, who's providing assistance with activities of daily living, things like meals, showers, getting dressed. And specifically, we're going to focus on 3 different areas of government-funded personal support services. So services provided for people with developmental disabilities within the developmental sector, attendant services for people with physical disability, and home care services, which are a little bit more generic in terms of the population that they apply to, but are provided through the CCAC, which is called the Community Care Access Centre, which is home health services in Ontario. There's other support services like acquired brain injury services and supportive housing. There's also mental health supportive housing, but we had to pick an area where we could focus, and we chose these because these were the contexts where the participants were most likely to live. So the first one that I'm going to go over is the developmental Services Ontario. So Developmental Services Ontario does not actually provide any services in and of themselves, but they're the central access point in Ontario for any services, funding, or support for people with developmental disabilities. So agencies like Community Living or RENA or Montage, they still provide their own services and they have their own unique mandates, but you can't access any of these services without first completing the intake process through Developmental Services Ontario. So what that means is that Developmental Services Ontario has specific eligibility criteria that they're trying to confirm for each applicant. And then once that's confirmed, they have a specific intake process in order to determine what someone's needs might be and the level of intensity of support that the person needs. So in terms of eligibility, specifically to qualify, you need to have an age of onset of your disability before 18, an IQ score below 70 on a standardized IQ test, and a history of needing habilitative supports or having poor adaptive functioning. So right off the gate, there are some challenges in terms of obtaining some of this documentation, where you can obtain it. The psychoeducational assessments are typically quite expensive, and so that can often be a barrier right from the beginning. And getting communication supports when you get these type of assessments. And then the second sort of intake process would be this 4-hour-long interview called the Support Intensity Scale. So they sit with you and they ask you a standardized series of questions about what your support needs are. I've sat through many of these and they're quite lengthy. They do allow for breaks or to do it in as many sessions as you want. But currently right now there's a wait list to get this assessment. So even once you prove that you have your eligibility criteria in place, there's then in Toronto, it's a 2-year wait list to get this assessment. And then from there, you're placed on the wait list for a variety of services and supports through the developmental sector. And that can include anything from direct funding, which is called passport funding in the developmental sector, that you can spend on respite or recreational programming. It's very flexible how you can choose to use this money. Services like person-centered planning, which is having someone come to your home and help you create a life plan. Adult protective service worker, family support worker. The services, there's sort of a standardized list on the DSO website of what's offered, but they tend to vary a little bit according to the agencies that offer them and the region that you're in. And then lastly, which is probably the most important service, would be residential services. So there's currently 7 different types of residential settings within the developmental sector, ranging from getting your own apartment and having someone check in on you once a week, and that's the service, the supportive housing part of it, to very intensive settings with group homes that have 24-hour staff. So there's quite a wide variety of what's offered within that sector. And then for attendant services, these are services that are specifically for people with physical disabilities. And it's called a service on purpose. So the sector purposely avoids using the word care because the idea is that consumers are directing their own service. So it's consumer-directed physical assistance with routine activities of daily living. So someone will show up and you say, I'd like you to cook my breakfast. I want eggs today. The eggs are in the fridge. I'd like you to go and get them and make them scrambled. So all aspects of the service are supposed to be directed by the consumer themselves, in contrast to the developmental sector where there may be less direction from the consumer themselves, depending on the model. In order to be eligible, you have to be over 16, able to direct your care, as I mentioned, and have a physical disability. The staff in this model are not really supposed to assist you with decisions around finances, health, or they're there to specifically do just the tasks that you ask. The application process for this varies considerably around the province still. So if you're in Toronto, there's a centralized waiting list to apply through the Centre for Independent Living, CILT. But everywhere else, you kind of apply individually, and you look it up through there's there's like a green book, like an actual book online, of a directory of attendant services. And depending on the region, each individual provider may have their own sort of process for how you apply for attendant services. Typically, though, obviously they check to make sure you meet the eligibility criteria. They do some type of intake assessment or interview to determine, and in many cases there are wait lists. They aren't as difficult as the developmental sector in terms of wait lists for housing, but they are there. And then from there you go on to sign a service contract typically, and then you begin to receive services. So there's several models of service within this. There's outreach attendant services, which means that you have your own apartment or your own home, and attendants come for short periods of time to help you within your home. Usually there's limits on the number of hours that you can receive for outreach attendant services, so they typically will not come many times a day. They'll often come once a day for, say, a 2-hour time period per day, and you often cluster the activities you want them to do within that booking. So they'll come, they'll help you with dinner, they'll help you with a shower, they'll help you do your laundry, for example. It might be like a cluster for a booking. So obviously that model works for people with mild to moderate levels of disability who may also have support from a family or other supports in place to make that work. It may not be enough hours for everybody. And so the next model provides much more support and has more hours of availability and more on-call. So that's called the Supportive Service Living Unit or supportive housing. And essentially, that's having somebody on site 24/7 in terms of availability. Typically, these are in regular apartment buildings, and there's one apartment building that's designated for the attendants to stay and hang out in 24/7, and you have your own private apartment that you pay rent on, that's yours, and you have bookings, so you'll have a morning booking to get up with breakfast and shower and all those things, and a lunch booking, a dinner booking, a bedtime booking, but you can call them at any point to have them come up if you had any needs. So this actually allows for people to live with very severe disabilities and a variety of different medical conditions as well. So we've had people with ventilators live in this type of model of care, and they use the pager to call the staff for suctioning or if something goes wrong with their vent. So it's a model that allows for a really wide range of situations that's commonly used. So, and it's becoming more and more looked at by the government because it is an alternative to hospital care or more expensive models of care, and it's also something that's more desirable for a lot of people. The last one I want to talk about, I just have a typo in here. I put direct service funding, but it's direct funding, which is again becoming very popular, and the government is actually regularly contributing more funding for this program. And direct funding is exactly what it sounds like. So they provide the person with the disability their own funding to hire their own attendants and act as a business owner, essentially. So you do have to know how that works in terms of taxes and benefits for your employees and the rights of your employees and all of those types of things. But they provide you with some support around that. You can hire an accountant to help you, and they help you with the funding for that. And there's a lot of mentorship included in the program to help people get over some of the initial hesitation around starting up something like that. So the last stream that I was going to cover are home care services, and I would say that this is one of the most common services that people use with disabilities and across the lifespan. So these are available through the Community Care Access Center, and essentially the type of personal support we're talking about would be personal support workers coming into your home to assist you with bathing, eating, hygiene, etc. But I put all of the other services that are offered through the CCAC because you often end up accessing multiple services when you try to access just that one service. So the way the intake works is really important to note because it has a lot of relevance for when you apply for other types of housing as well. So when you make a referral to CCAC, you can self-refer and you can call yourself and say, I need these services. But typically it's a family doctor that makes the referral and it's accepted by the CCAC. They accept it in terms of priority, and they'll often do the assessment for somebody who requires support for bathing quite quickly because it's a safety risk. And they will send someone out who, again, will do a standardized assessment. And in this case, it's typically the RAI. And we know that from previous reports that people with speech and language disabilities often have difficulties with this assessment. So the issue being that whenever you have a standardized assessment that's designed to apply broadly to a large group of people, there are going to be difficulties for subpopulations, and definitely people with speech and language disabilities have reported experiencing difficulties with these assessments and saying that they didn't feel that their care needs were accurately represented when they had completed this. So we did hear this in some of the stories that were told to us, and I wanted to sort of mention it as a heads up. The other issue that can happen with these assessments is that often at the beginning, people consent to have this information shared more broadly. And so it may end up being shared with an attendant service provider in the area. And the idea is that it's supposed to help you and reduce the amount of times people ask you the same questions and all those types of things. But if you have very specific accommodation needs and you have a speech and language disability, if that assessment is actually reflecting some inaccuracies, that can be problematic, obviously. So I wanted to give the heads up on that because we have had issues with that. Again, there are limits in terms of what the number of hours that can be offered for PSW support within the home. And so it's not a model that you can rely on for housing to live independently typically if you're a person with a disability. In and of itself, the number of hours with PSW support typically are not enough to make that work. So these are usually it's usually a model where a person is living with a family member who primarily provides support, and then this is a supplementary support that's added in. However, the case managers are often the ones who end up being responsible for trying to find supportive housing options and assisting people in applying for supportive housing options when family members are no longer able to support their loved ones in this type of setting. So I tried to keep it as brief as possible, and I agree with Barbara. It is a very confusing system. All of these sort of services and supports, they end up intersecting. They often use jargon that sounds the same across different sectors but means different things depending on which organization or sector you're speaking to. And I definitely welcome any questions that anybody has at the end of this, and you're welcome to type them in as you think of them, because it is a difficult system to navigate. And I know we mentioned in the last webinar that the consequences of not navigating it can be really tricky for people.
Megan, just before we go to Brendan. So, Megan, can you hear me? I'm just asking, it's Barbara, and I just wanted to ask a question. Before we go to Brendan, I don't mean to put you on the spot with this, but can you talk a little bit about the communication support within some of these models for people? What do they say about communication support? I know the
Oh yes, okay.
If you can do it briefly, I know we'll come into we'll talk.
Yes, of course.
What is your overall feeling about that?
So with the Community Care Access Center, staff are all supposed to have training with regards to the AODA. So they're familiar with the language of accommodation, but they're likely not familiar with the specific needs of people with speech and language disabilities, and it's likely a group that they don't encounter very frequently. So it is something where the role of speech and language pathologists, I think, as we mentioned in previous webinars, would be really, really critical in outlining what accommodations would be required, both for the assessment and for the actual personal support itself. And the amount of training that frontline staff have would vary considerably. With regards to attendant services, they do specifically state that they provide communication support on their website in terms of CILT, the Center for Independent Living, and many of the individual service providers have things in their service contracts related to communication support, but very rarely do they articulate what that means in detail. And again, the training really varies considerably, and what supports are provided really varies considerably. So you have some supportive housing units that provide a lot of support and will, provide someone to go with someone to go to the bank, to go grocery shopping, to help them with communication in day-to-day settings, and it extends sort of outside of the home. You have others that clearly state that the boundaries are we provide support within the home, and you have others that may or may not understand communication accommodations within directing itself and see it as an inability to direct that the person has a communication disability. So you have a very wide range.
So it's a real
if that,
hodgepodge of whatever you get. It's
yes.
So I know that we've triggered some questions coming in, and
I can see people typing.
Okay, and Al, I'll just say yours, and then we're going to go to Brendan. Al, you're saying we need to be teachers again and again, and I would say again and again. And this would be Al, who I know Al, he uses augmentative communication, and he's always been a teacher for his staff. So thanks for that comment. Brendan, let's move on to
yeah.
Thank you so much, Megan. We have lots of questions, and we're coming back to you. But let's go to Brendan right now.
Sounds good. Thank you, Barbara, and thank you, Megan. So I think we may have skipped a slide here.
Beg your pardon, that's my fault.
Oh, no problem.
No?
Oops, there it goes.
Is that right?
Okay, here we are. Okay, so I'm going to provide everyone with a brief overview of the relevant legislation. So I think this part of the seminar is going to be quite short, and then I'll be back in a few minutes later on. But there are a few different laws or a few different statutes that govern the subject area that we're talking about today. Megan did a great job of sort of providing an overview of the various areas earlier in the presentation, and so what I'm going to do now is just sort of identify the laws that govern each specific type of service. So, excuse me. We'll start off with developmental services, and as Megan mentioned, developmental services sort of applies to individuals with a developmental disability here in Ontario. There's a new, well, I was going to say a new act, but the act is, I guess, been around for about 8 years now, called the Services and Supports to Promote the Social Inclusion of Persons with Developmental Disabilities Act. That came around in 2008 and replaced the old Developmental Services Act. And I believe there may be a small typo there. Instead of people, it should say persons. The act is referred to as the Social Inclusion Act, just as an abbreviated form. The act governs service providers, organizations that provide services to individuals with developmental disabilities here in Ontario, who are at least 18 years of age. One of the main tenets of this legislation is a regulation called the Quality Assurance Measures. And the Quality Assurance Measures, for anyone who's interested, really does outline all of the reporting and compliance requirements of service providers in the sector. So everything from having, the requirements of having its own policies in place, to, speaking about policies governing supported banking or financial management, or policies governing the requirement that service providers report any kind of suspected abuse that may result in criminal activity to the authorities. So there are a wide range of compliance requirements that service providers in the developmental services sector have to adhere to based on the requirements of the quality assurance measures. And moving on to attendant services. So attendant services is governed by an act called the Home Care and Community Services Act. The Home Care and Community Services Act mainly applies to CCACs or community care access centers, but it may also apply to other programs such as supportive housing and attendant outreach. And one of the main pieces of this act is something called the Bill of Rights. And the Bill of Rights is set out in Part 3 of the Home Care and Community Services Act. And the Bill of Rights generally says that you have a number of rights as a consumer. You've got a right to be treated with respect and free from abuse, and to have your privacy protected and dignity honored, to have your needs and preferences respected, to receive information about services that you're getting, and to take part and contribute to any sort of decisions regarding your services. It gives you the right to consent or refuse service, to provide feedback on services that are being provided, to receive information about legislation and policies regarding home care, and to give you information on how to make a complaint. And it also speaks to the right of having your personal records or your personal information kept confidential.
Okay, thank you, Brendan.
Okay, back to you, Barbara. Yes.
Thanks, Brendan. Well, you kind of stole my thunder there, Brendan, because I was going to talk about the Home Care Bill of Rights.
Oh, my apologies. My apologies.
Listen, it's okay because we can always talk about these. Don't worry. You succinctly summarized them, and now everybody has to kind of listen to me going through them a little bit more slowly. But that's okay. That's okay. We can all hear them and we can all think about them again. And I think it's important that we know what these are. They sound very good, but and it sounds simple and straightforward, but we hear over and over and over from people with speech and language disabilities how some of these rights are being ignored or violated. So we just wanted to not spend a great deal of time on this, but to just go over them again. As Brendan said, the first one is about being treated in a respectful manner and to be free from any form of abuse, whether it's mental, physical, sexual abuse, financial abuse. It basically is talking about being given your services in a respectful way, which means attending to you, listening to you, having your opinions and directions taken seriously. And it talks about the fact that you must never be abused by a service provider within this context, or by anybody, obviously. The second one is about the right to be dealt with in a manner that respects your dignity, privacy, and promotes your autonomy. So that means that service providers must treat your personal life as private. So, for example, not talking about your private life with somebody else, or sharing it with other residents, or sharing it with other staff, and also giving you your own personal space and time. This right also talks about your autonomy, the right to make your own decisions. And that would include, for a lot of us, choosing somebody that you trust to help you make those decisions. The third one is the right to be dealt with in a manner that recognizes your individuality and that responds to your needs and preferences, including preferences based on ethnic, spiritual, linguistic, familial, and cultural factors. So that's the actual wording. So it really is talking about recognizing you as an individual and recognizing that you have distinct likes and dislikes, and you have preferences. And that, for people with speech and language disability, that preference must also include how you choose to communicate. So if you choose to use your speech and to clarify with your AAC system, you wouldn't, you can't expect a service provider to be telling you that you must say everything on your device or use your display to communicate with them. You have choices in that. Now we interpret that linguistic preference as being very significant for people who use AAC. So service providers are basically being told here that they must respect all of these aspects about you and who you are. The Home Care Bill of Rights has a right that says that you can have information about community services provided to you and to be told who will be providing these services. So your service provider should explain how your services will be delivered, and that there would be, and explain the fine print. So basically it's saying, put it all out there in ways that you understand, and that they can't change your service without your knowledge or without explaining how it's going to affect you. This, of course, sounds very good, but it doesn't always happen. The next right is the right to participate in the assessment of your requirements, development of your service plan, review of your requirements, evaluation and revisions of your service plan. It's basically saying here that you, as the consumer of this service, you play a very important role in defining how your services are given to you. And the service provider must listen and be directed by you. And that you should feel very comfortable giving feedback and evaluating your services. Number 6 is the right to give or to refuse services. So you're in control, basically. You can agree or refuse services and or how your services are delivered. It's all about control. The next one says you have the right to raise concerns or request changes in your services without anyone taking action against you. And this is basically the freedom to speak out or communicate if problems arise. And your service provider should never do anything that makes you feel afraid, and you should never be punished for communicating or complaining about your services. Number 8, you have the right to be informed about laws, rules, and policies affecting the operation of services and how to make complaints. So you should be told who's in charge, how to make a complaint. You should be given that in writing as well. If you have difficulty reading, it should be explained to you. You should know exactly what to do and at what level you go to make a complaint. And the last one is you have the right to have your records kept confidential in accordance with the law. So your service providers must keep your records confidential, and they can only share them with the providers who really need to know, so maybe other attendants. And you have a right to see your records. So that's just a summary of the Home Care Bill of Rights that I think we need to be cognizant of at all times. And I'm speaking to the speech pathologists on board here. This is, if you're in Ontario and you have somebody whose services are being provided and is governed by the Home Care Bill of Rights, I think it's important for us to go over that and to make sure that we're providing the vocabulary and the tools so that people can negotiate and communicate around all of these rights. It's a really good framework for building up vocabularies for people and skills. I'm now going to hand it back to you, Brendan, to talk to us about when your rights are ignored.
Okay, sure. Thank you. Thank you, Barbara. There are a couple of options to consider, a couple of avenues with regards to complaint processes and legal options to consider when your rights are being ignored. And you know, the option that you sort of select, or the legal avenue that pursue, is really going to be based on the particular situation at hand, based on what has actually happened. So we're going to cover a couple of different options here today. So number one is making a complaint to the organization that is providing the services. What we're sort of speaking about here is you know, any organization that is providing services to you is required to have a complaint process available to its consumers. And so if there is any sort of breach in terms of the type or the quality of service that is, and I think the slides just sort of skipped, being provided, then I would recommend starting with making asking for the complaint policy, and filing a complaint with the organization that is actually providing the service. The second is suing the organization for breach of contract, and we'll talk a little bit more about that in just a couple of minutes. But this usually or does involve a civil action being initiated in court. And thirdly, we will touch on a few other options. I already covered a little bit about making a complaint, but a couple of added points that I wanted to make sure I shared was make sure that there is that you have someone with you to support you when making the complaint, and it's always important to document exactly what happened. So not only documenting what happened, but documenting any kind of verbal response that you may receive to your initial complaint. So you want to keep a paper trail just in case you have to escalate the complaint to another level. Follow the complaint process of the service agency, and that's really what we've been speaking about here. I think it's important anytime you begin to receive service from a new agency that you make yourself aware of the complaint process that's in place. If it isn't provided to you upon the initiation of service, I would definitely ask for it before you sign any kind of service agreement. Okay. Appealing an agency's decision. So if you are not satisfied with the outcome of the dispute resolution process with the agency, then there are a couple of options that you can pursue. So one is you can call the long-term care action line, and the long care the long care action line is a service provided by the Ministry of Health, and it's really a service that hears concerns and complaints from individuals that are receiving services in either long-term care homes or CCACs, Community Care Access Centers. The action line is bilingual, and you can call with sort of any problems, concerns, or complaints that you have about the services that you are you're receiving. The when you call into the long-term care action line, the staff will ask you, or they'll first inquire whether or not you have contacted, if it's a CCAC related issue, whether or not you've contacted CCAC with regards to your concern, and if you haven't, they'll ask for your consent to inform CCAC of this concern, and may even call CCAC on your behalf to discuss any of the issues at hand. You don't have to disclose your name. You can call anonymously, but obviously if there is an issue with service and you're looking to have that issue rectified or that issue addressed, then I would suggest that you do disclose your identifying information. You can also request what's called an independent complaints facilitator. So this is in addition to the long-term care action line. You have the option of speaking with an ICF to discuss the issues at hand. When you request an ICF, they will not get they typically don't respond to you right away. They will contact you by phone, usually within 10 business days. This is another avenue that you as a consumer can access in terms of having someone contact CCAC on your behalf to try to address any kind of concerns. And again, I think the last point that I wanted to make here is make sure that the ICF does ask you for your consent before they move forward and contact CCAC on your behalf. They typically wouldn't contact CCAC on your behalf without your permission, but I think it's important to point that out. The Health Services Appeal and Review Board can be contacted for eligibility issues. So generally speaking, you've got a right to appeal to this board for a number of matters. There are two types of matters, however, that are specifically not addressed by the board, and they relate to the quality of services that you're receiving and any kind of complaints that you have under the Bill of Rights that we discussed earlier. But there are all sorts of other complaints that can be that can sort of be addressed by the board. For example, eligibility for CCAC services if you don't feel that you are receiving the amount of service that you need or the type of service that you need. Those matters can be heard by the board as well. And I believe that we have some handouts that we will be circulating that has the contact information on them for the Long-Term Care Action Line, the ICF, as well as the Health Services Appeal and Review Board. So anytime you enter into sort of a relationship with a service provider, there's this implied contract for services. So, I mean, first of all, I would definitely suggest that, as I mentioned earlier, when you begin service with a new provider, that you ask for a written contract, and the written contract will typically identify the service provider's responsibilities. It should identify a complaint or dispute resolution process and sort of govern the relationship between you and the service provider. But if there is no written contract, there's an implied contract, meaning that there is an onus or responsibility for the service provider to provide a certain level of service to you. If there is a breach of either a written contract or an implied contract for services, then I would recommend that you do seek legal advice before pursuing the matter, because the lawyer can sort of help you do a number of things. They can help you identify any potential damage or harm done, and then what they're able to do is once that is identified, then they'll be able to advise you on what kind of compensation they would suggest that you seek. Sorry. A couple of other points here with suing for breach of contract. As I mentioned when I sort of started this this section, when you're suing for breach of contract, you're actually starting a civil action in court. So you'd be looking at suing the service provider in civil court, and ultimately the dispute would either be settled outside of court, or if it actually does make it to court, then usually a judge will decide on how the case should be resolved. But a couple of things to note here. I mean, generally speaking, you're going to be retaining a lawyer to help you in court. You don't really want to go into court unrepresented. And anytime you retain a lawyer, you're obviously going to incur lawyer fees and or expenses as well. Most lawyers will charge an hourly rate. There will be some lawyers that will work on a contingency basis, meaning that you don't have to pay anything up front, and you don't have to pay anything if the lawyer is unsuccessful in achieving or gaining some sort of compensation for you. But if compensation is achieved either through a settlement or through a decision of the court, then the lawyer's fee is usually a percentage of that compensation. Usually, when you're suing for breach of contract and you're initiating the civil action, you'd be sort of starting it in court, but the organization or the person that you're alleging any kind of breach of contract would be a party to the litigation as well. So you'd have to be prepared typically to face them in the courtroom. So I think long and hard before suing for breach of contract and suing a civil action, because not only is it usually a long and drawn out process, it can be expensive. And even if you win, the win is really only beneficial if the other side has the ability to pay. So if the service organization, the service provider, or the individual doesn't have the ability to pay, then it kind of defeats the purpose of you starting the civil action in the first place.
Brendan, can I just give you a heads up that we're running a little bit short on time?
Sure. So I think this is my last slide here on with regards to these options. So I'll be very quick. Depending on the nature of the complaint, there may be some other options that you could pursue. So one is reporting to the police, and I believe we're going to speak or you're going to have a webinar that covers a little bit more about reporting abuse to the police in a couple of weeks. Filing a report with professional regulatory colleges would be another option. Filing a human rights complaint. We spoke extensively about filing of human rights complaints a couple of weeks ago. I'll just sort of reemphasize the fact that if you are seeking compensation or seeking some sort of decision from the Human Rights Tribunal, that Ontario does have the Human Rights Legal Support Center, which is a free service that you can call to gain access to summary legal advice, and in some cases they may even initiate a claim on your behalf and represent you before the tribunal. And if you feel that your privacy rights have been breached, you can also file a complaint with Ontario's Information and Privacy Commissioner. So I'll turn it back over to you, Megan, I believe now, or Barbara.
It's me. Thank you very much, Brendan, and I'm sorry for rushing you at the end there, but
no problem.
I think we can address some of those issues through the questions. So sure. Here's one, and I think let me read it first, and then I'm going to ask Megan and you to respond to it. So people with speech and language disabilities who are capable of directing their attendance services can be denied access to personal support services because the intake workers may conduct interviews without providing them with the accommodations and supports they require. For example, some interviews take place over the telephone, which is very challenging for people with speech and language disabilities. And some interviews may happen without giving the person someone to assist them communicating. How can the rights of people with communication disabilities be protected in these situations? And I'm going to start with asking Megan to respond to it, and then Brendan, if you've got some thoughts on that.
Sure. So this definitely used to be a much more commonplace problem than it is today, fortunately, but it still does occur. So in Toronto, the attendant service interviews are all in person for agencies in the Toronto region that you apply through Centre for Independent Living, but they did have issues with that in the past. And I can't speak for across Ontario if this is still something that happens on occasion in terms of the interview being over the telephone. So again, I think a lot of our stuff goes back to the first webinar we did on the AODA. And if you use the language of accommodation and you explain your needs for accommodation up front, often that can help head this off. The other issue that comes up, which I mentioned briefly, is that sometimes information is shared between organizations, and although the person may have provided consent for this to happen, they may not have fully understood how widely or broadly the results of an assessment were going to be shared. So when I talked about the RAI being done by a CCAC worker, and maybe that's shared with the attendant service provider, you do want to make sure that you're asking where this information will be shared whenever you do an interview with an attendant provider or with a CCAC, and ask to review the results before they're shared or placed in a permanent record, so that you can take a look to correct any inaccuracies or anything that you take issue with, or decide to not consent to have it shared if that's the route that you go down. So I think it's a fine balance because there's such a shortage of housing between advocating for your rights and advocating for your accommodations, and demonstrating how capable you are of directing, and demonstrating that you're an appropriate candidate for this particular position or this particular housing space, because there will be multiple people that are interviewed at the same time as well. So you're sort of balancing out looking very attractive to the manager to be selected, with the fact that you want to make sure that they're really addressing your communication needs as well.
That's so true.
So I think Brendan can maybe speak a little bit to
Megan, I was just going to add, play an enormous role there in preparing people, first of all, to know their rights, to know that they can ask for an interview instead of being interviewed over the telephone, and also that they can request someone to assist with communication. That's something that I think we need to be flagging.
Totally.
For youth and for the AAC clinics or the speech pathologists supporting them going forward with this. Brendan, would you like to add anything to that?
Sure. I mean, I echo both of your comments. I think just to reemphasize the fact that the AODA is in place to address situations just like this. So, you know, if an individual is having a concern as identified here, I would request that they ask for a copy of the organization's AODA policy and ensure that the organization is acting in compliance with their own policy, and if they're not, they can report a breach to the appropriate authorities. Obviously, the other route here that a person could go is pursuing a human rights complaint with the Human Rights Tribunal. So again, reaching out to the Human Rights Legal Support Center for some summary advice and determining whether or not it makes sense to file a human rights complaint if discrimination is taking place.
And just like a last point on this, I think there's a lot of confusion between ability to direct and the fact that the person has a communication disability. And so some attendant service providers confuse those two issues and think that the communication disability interferes with the ability to direct. So in many cases, writing these kind of letters to show what accommodations you need actually is supportive in making the person understand how you would direct your own care or own services in this case, and the fact that you're able to articulate exactly what would be needed to make this situation work. So I think people sometimes are reluctant to do this because they don't want to appear fussy and they want to look like a good candidate, but it actually addresses some of the concerns that the interviewer would have going into the interview up front and actually makes the service provider more comfortable typically, rather than less comfortable.
Thank you, Megan. Again, we could talk forever about this.
Yeah.
I'm going to move it on, but I want to make sure that we realize that the AODA is right now not strong enough. It does not meaningful enough to include the needs of people with speech and language disabilities. I refer you back to our very first webinar where we talk about the fact that CDAC is asking for amendments and to strengthen it. We know it's not there, and therefore I come back to Al's point. We are teachers, teachers, teachers all the time until perhaps in the future this will be ingrained and embedded in it, but we're not there yet. We still need to tell people what is required. The next question is it's a bit about this, so I'm going to put this back to you, Megan. It takes me time to spell out everything I want to say, much longer than it takes to speak the message. Am I legally entitled to get extra time for my attendance services to accommodate my slow communication speed?
So we definitely heard stories of people who successfully made challenges, some of them in a legal context, to obtain increased numbers of hours and supports in attendance service settings for their communication needs. I would suggest always that you put a request in writing and use the wording of accommodations. And definitely too, there's strategies that this has nothing to do with the legal rights issues. There's definitely strategies for communicating in attendance service settings in a more efficient way, pre-programming phrases, commonly used phrases, or instructions. We had one client with a very severe speech and language disability who was typing at an incredibly slow speed, and they actually they trained one attendant very well and made videos, instructional videos that they would play, and they had a very elaborate way of doing their hair, and they had that instead of trying to spell out something that's going to take a really long time. So it's kind of a combination of advocating for as much support as you can obtain within that service contract, because there are limits as to the maximum number of hours that are offered via government-funded services, including attendance services. And combining that advocacy with some strategies, which I think speech and language pathologists are really well equipped to help people out in developing more efficient strategies for communication in that setting.
Exactly. I'm going to move to the next question. I'm
Yep.
going to skip through because this one has a
Okay.
legal twist to it. Most personal support service providers have no training in communication. And that is true. And there are no communication standards of practice in place. It usually falls to the individual or family member to provide this training. And Al, you have just said that. I typed into the chat box. Are there legal obligations for organizations to train their staff on how to communicate with people who have communication disabilities? Megan, I'll start with you and then ask Brenda.
Well, I don't know. In terms of even if there are legal obligations for them to train staff, because of the diversity of the ways that people communicate and their individual needs, and the variability in the quality of training that people receive, even when you have an organization with very good intentions that tries to train their staff universally, you still are going to have issues in place for individual people with individual workers frontline and what kind of training they need in that setting. So I still would recommend that the best approach is to set up a structure so that you're reviewing your service contract and you're reviewing the training needs of staff on a regular basis, like maybe annually or biannually with the manager, so that more training sessions can be set up specifically that are training sessions, not within your bookings, to address any concerns that are coming up, particularly if you do have an extremely slow typing speed, for example, or something that you're recognizing that frontline staff are having real difficulty with, like often, for example, in bed, when you don't have access to an AAC device, if that was what your typical method would be, or technology technology or in the shower, for example. So this is going to come back to trying to set up a structure with the organization and your service contract, regardless of the legal obligation. But I'll leave that part to Brendan to speak to.
Yeah, thanks, Megan, and I do sort of agree with Barbara's comments regarding the AODA and the gaps that are in the legislation when it comes to addressing issues related to communication disabilities. That being said, organizations are required to provide training to their staff who are interacting with the public, organizations of a certain size. So any organization with 20 more employees has to train their staff who deal with the public on a regular basis when it comes to interacting with people with various types of disabilities, including communication disabilities. And I know that it's not specifically identified in the legislation, but the training should include that. So I know it doesn't most of the time, but arguably, given the requirements of the legislation, that type of training should be incorporated into the offerings of the organization to their staff.
Thank you, Brendan. I would agree with you totally. Here's the next question. We've heard of people with communication disabilities being pressured to move into long-term care facilities because of lack of attendance services in their areas or because of lack of service time from an organization. What rights does a person have in these situations?
So again, I think that goes back to our capacity webinar in terms of you have to provide consent in order to move into these settings. People can't force you, so to speak, but the issue can be that if you don't have anyone that's attending to your needs in terms of for care or for basic activities of daily living, there are a lot of young people who are living in long-term care facilities because there were no other options available. There are a lot of people living in hospitals at levels of alternative level of care, they call them, which essentially means you don't actually need the care from a nurse, but you're there because there's no other option for housing. And I've heard of people with developmental disabilities. It's not that uncommon to end up in homeless shelters. I've been working with some people in Surrey Place, and I've heard several stories about that. So, I think in these sort of situations, the first step I would recommend for people is to get as much support as possible, and the squeaky wheel gets the grease in terms of moving to the top of wait lists and getting access to better options. So if you're in a situation you're at risk of going to a long-term care facility, any third party that you can bring in, whether that's an organization like Ontario Federation for Cerebral Palsy or any other kind of advocacy group, family, friends, writing your MPP, anything that you can do to attract attention to your situation and the fact that you want a different model of housing is sort of what needs to happen. And once you're in long-term care, speaking to the social worker about the fact that you want to move out, getting on the appropriate wait lists, all of those things are really important in those situations. Yes, no one can, force you, but yeah.
I'm going to move on, but thank you. That's really good advice. Brendan, here's the one for you. A man who has had a number of strokes and now has aphasia wants to live in the community. His wife wants him to move into a long-term care facility. What rights does he have?
Well, just to sort of repeat what Megan just said, consent is required from somebody in order for the individual to move into a long-term care facility. So if the individual is still capable of making this decision, then it's his decision to make. His wife would not have any say in terms of where he lives. If he is found incapable of making that decision, then his wife may have the authority to make that decision on his behalf. And I say may because he may have entered into power of attorney for personal care, whereby that a POA document where he appointed somebody else other than his wife to make that decision for him. If he doesn't have a power of attorney for personal care in place, then arguably his wife would sort of be next in line to make that decision.
Thank you, Brendan. Can an organization force me to accept services from an attendant that I don't feel safe with? Megan, can you address that one?
Okay, so I think again that's where the importance of looking at your service contract and talking with your manager about what situations could come up and what the process is for them dealing with those situations. I know oftentimes people are reluctant to complain or report because they're afraid of the fact that it's going to come straight back to the staff, and then that staff person is going to be resentful of them. So you really want to outline in detail how they manage complaints, and what the rights of the employee are, and how they go about dealing with an employee who is, in this case, I'm assuming not competent either, because of either there's a safety issue in terms of how they're doing, say, safe transfers or something like that, or not safe in terms of how they feel emotionally, which would go back to the Bill of Rights.
Oh, thank you, Megan. I want to encourage people, if you have questions, now is the time to be typing them into the chat box, because we're getting on with time here. So please, if you do have some questions, pop them on the chat box and we'll keep on going. Do I have a right to request and get a gender-specific attendant to provide my services? Megan, what is your experience there? Do I have a right for that?
Typically what happens is that this is the norm, that you get men providing care to men and women providing care to women, but sometimes it's difficult to accommodate because it's a very female-dominated industry in terms of hiring personal support workers to be attendants, and sometimes they have difficulty keeping consistent male staff. So typically they strive to accommodate that, but there are situations where that is not accommodated, and I don't know in terms of the legal rights. I'd have to defer to Brennan's answer with that, but it's something that you can definitely bring up with providers and management, and it's fairly well accepted within the attendant services organizations and culture that that's something that's respected, and people strive to provide that as much as possible.
Right. There are a few questions that I wanted to, I'm going to go to the chat box now. Tracy, you have your hand up, and I'm assuming that you would like us to address your issue here that you put in. If there are differences in the definition of terminology, is there any venue to encourage the development of a common set of definitions? I'm assuming you are talking about what is communication and what it really means and how it rolls out in this. This is probably the biggest issue that I have experienced in every single sector, whether I'm working in justice, whether I'm working in the accessibility directors, with a hospital setting, is what is communication and what does communication access really mean? So that is, you're absolutely right. There is no common understanding in how that would roll out and what essential communication means. Megan, would you like to respond to that?
Oh, totally. So in the context of supportive housing or support services, typically what happens is that they're divided by different ministries. So attendant services is funded by Ministry of Health, and Ministry of Community and Social Services funds the developmental sector, and that's often where these differing terminologies or terminology that are the same but have completely different meanings kind of rise up. Like the term independent living in the developmental sector is different than in attendant services. And I think the only way you get rid of this is through collaboration and cross-ministerial work. So there's a lot of work being done in the children's side, actually, between Ministry of Education, Ministry of Community and Social Services, Ministry of Health, to try and come up with more standardized definitions and language, but it's very slow and it's very difficult to have that kind of collaboration occur. And so for your frontline consumer, it's still kind of a maze.
And it is absolutely required that we have some input into defining how communication rolls out within these services. I think it's absolutely critical. We're often not at the discussion tables, and we should be. Cindy has says, what are the consequences of an agency not complying with the Bill of Rights? Now, Brendan, I think you, I will ask you to address that.
Sure. Well, I mean, I'm not sure what I mean, in terms of consequences, I guess, if there are many complaints about that particular agency, then CCAC may decide not to continue using that agency. I think it really does depend on the nature of the complaints or the nature of the breaches. It could be that an individual decides to sue the agency and is successful in suing the agency, and as a result of being sued and the award that the damages that have been awarded by the court, the agency may not be in a position to continue operating. So I think it really does depend. But generally speaking, I think if there are a lot of consequences about the same agency, then CCAC may take a second look at whether or not they want to contract with them for services.
Thanks, Brendan. Cindy's also asking, what is the complaint system, and is there any support for the individual to make a complaint? I think we addressed that, Cindy, in the sense that I think each agency has to put forward its complaint process and give that to the person, and that each agency would probably be somewhat different in that, and there'd be some similarities. Megan, do you want to address that?
Yeah, I think you're right, Barbara. So first, you complain to the agency, and if you're not satisfied, you can complain to CCAC. And you also have the option again of calling the long-term care action line.
Yeah, I think to comment on both of those questions, I think the consequences of a complaint vary from varying levels of bottom up. So there being a really bad reputation within the community about a particular service provider, or they receive bad media even. I've seen that happen before. Staff can be fired. They can lose funding or not be chosen to be funded by by CCAC, they stop using that agency, or yeah, they can be sued. So I think the consequences really vary, but those consequences don't come forward unless people make complaints. And I think at the core of some of this is the hesitancy and difficulty of making a complaint when you're in a situation where you feel quite vulnerable because these people provide a service that you're very reliant on, and that is in your home in a very personal setting. So, I think as a professional, I think the best thing that you can do is sort of try to help bolster people's supports around them and help educate people through the process of how you make a good complaint, and provide that emotional support during that process too.
Good questions. Good questions. We have run out of time.
Yeah.
I'm sorry. Let's do this again soon. Let's keep talking. I want to thank both Megan and Brendan for this very interesting webinar. You've made me think of so many issues. I wish we could go on. We've got some handouts for you. We're going to be sending them out tomorrow. An overview of the personal support services in Ontario, the Human Rights Bill of Rights, the Home Care Bill of Rights, relevant legislation and resources, and some suggestions for making a complaint about personal support services. Al, I have also noted your point that some of these organizations should provide an email in addition to a telephone number for people to use to get information. And I think that we've been saying that to a number of organizations, that they have to provide an email. So I totally agree with you. So as we come across it, and as we do this and we make connections, I'll certainly be telling them to put out their email address on their websites, and hope you will too. We will be sending you a feedback survey. please, please, and thank you to those of you who are giving us feedback regularly, and we look forward to your feedback on this one. And to seeing you again on June the 14th, the Tuesday, on reporting abuse and crimes within personal support services. Thank you all very much, and have a good evening. Goodbye now.
Thanks, Barbara.
Thanks,
Bye.
Brendan. Bye-bye.
Nate.
Thank you, Steve.